Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that is Security Gun Club right here in Woodinville, Washington. Hey, America, we need to talk. We need to talk about rogue judges and nationwide injunctions that come out of district courts, and now some legislation or legislative efforts underway to try to stop some of that insanity. But how insane is it, and should we actually think about stopping the insanity? I know it seems like a crazy question, but we're going to break it all down for you here in just a moment. So today, let's spend a few minutes and let's talk about fighting back on rogue judges. Be careful what you ask for. Okay, America, listen, we've already geeked out on nationwide injunctions from district court judges. Translation, how do we get politically motivated judges to put up roadblocks to stop a presidential administration from implementing the policy that the American people voted for? We have seen a massive influx in nationwide injunctions coming out of district courts scattered around the country, predominantly in the same handful of district courts. Shocking how it always seems to work that way. In some instances, shockingly, always coming out of one courtroom in a district court. Even more shocking how it always happens that way. This has sent a lot of people really into a conniption fit. It has sent some legislators back to put pen to paper, and we now have a bill which is actually passed out of the House of Representatives already. Today, we are talking about House Resolution 1526, sponsored by Darrell Issa of the state of California. This is a bill which is entitled No Rogue Rulings Act. Love the way they always come up with titles at the federal level. Now, this legislation, if enacted into law, and that is a big if, by the way, would read as follows. Except as provided in subsection B, notwithstanding any other provision of law, no United States District Court shall issue any order providing for injunctive relief, except in the case of such an order that is applicable only to limit the actions of a party to the case before such district court with respect to the party seeking injunctive relief from such district court and non-parties represented by such a party acting in a representative capacity pursuant to the federal rules of civil procedure. A very wordy way of saying, hey, listen, if you're a district court judge, you can issue an injunction against the party only for the named plaintiffs or anybody else that the plaintiff claims to be properly representing. Then the bill goes on to say that the only way a nationwide injunction could be administered or issued from the district court level is in the following circumstances. If a case is brought by two or more states located in different circuits challenging an action by the executive branch, that case shall be referred to a three-judge panel selected pursuant to Section 2284, except that the selection of judges shall be random and not by the chief judge of the circuit. The three-judge panel may issue an injunction that would otherwise be prohibited under subsection A and shall consider the interest of justice, the risk of irreparable harm to non-parties, and the preservation of the constitutional separation of powers in determining whether to issue such an order. Okay, so the legislation says you don't get to issue nationwide injunctions unless you got competing lawsuits in different circuits all asking for the same injunctive relief. Then we randomly put together a three-judge panel and go from there. Now, as I mentioned, this is already passed out of the House of Representatives predominantly on party lines. What is the likelihood that this is going to gain the 60 votes needed to get out of the Senate? Somewhere between slim and none, and slim currently is out of town. There is no way on God's green earth that we're going to get 60 votes on this piece of legislation. But I really want all of us to take a step back for a second and realize a couple of things. Number one, nationwide injunctions in all likelihood have always been available to the federal district courts. It's just that for a majority of our country's history, the judges at the federal district courts were reserved in the remedies that they structured. They realized what an extreme circumstance it would actually take to issue such a remedy and therefore did not do it. Then along came the election of President Donald Trump the first time around and the warfare that was waged against them. And at that point, we began to see many very politically motivated district court judges start issuing nationwide injunctions. That has continued at a feverish pace now on President Trump's second term, predominantly coming out of a small handful of courts. Now, we have already done this video here about trying to impeach these judges, which again is tantamount to trying to throw rocks at the moon. Plus, there is a long-standing precedent that we don't really impeach judges simply because we strongly disagree with their rulings. But I want you to go back in your time machine, for those of us here in the 2A sphere, and remember some of the litigation as it related to the pistol brace and as it related to forced reset triggers. Because in those instances, there were nationwide injunctions granted by district courts. And yes, I understand that we believe that these were extreme violations of our constitutional rights. But remember, in both instances, what ultimately undid the forced reset trigger determination and the pistol brace rule was not your Second Amendment rights, but was rather the Administrative Procedure Act. And so we have to be very, very careful what we ask for here, because we just might get it. Let's go into our time machine 10 years in the future and say that the political winds have significantly shifted, but that this bill has now become law. So there is no nationwide injunctions. And now you have a president who is hell-bent on complete and utter civilian disarmament and passes legislation, or perhaps even issues an executive order that mandates the confiscation of firearms nationwide. Would you want a district court in that moment of time to be able to issue a nationwide injunction? So listen, I bring this to everyone's attention because even though this bill is likely not going to become legislation, unfortunately, the way the district court is acting as it relates to President Trump, this type of legislation will be discussed again in the future. And maybe there will be a refined bill that has a better chance of passing. But at the end of the day, America, I want you to understand that we have a tendency sometimes to just overreact to things and think that we just need to pass some legislation to stop this right away. But anytime we have that reaction, we need to pause for a moment. We need to ask ourselves, what's it going to feel like if the shoe is on the other foot? Okay, once again, it's House Resolution 1526. We're going to link it up down below so that you guys can geek out on it for yourself. Don't have to take our word for it. If you do have any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. If you got an idea for a video we should be doing around here, cool. Tell us all about it by clicking on that link right there. If you want to subscribe to the monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, America, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe. They're saying, you know, what happens is these people get involved in these situations and then they're just denied coverage.
Yeah.
And I think that the model of what some of these companies run, as far as they run like insurance companies, actually leads to that result a little bit. But, you know, that's a fair criticism. People are going to invest money and you're going to be there when it hits the fan, and then it hits the fan and you're not there anymore. What can Right to Bear say that's going to make them different?
Well, yeah, I think that's a great point. You know, I come from the insurance industry, so I know it well. I know that insurance contracts are written by attorneys for the benefit of the insurance company, not the insured.
That's right.
So what we did at Right to Bear is, you know, we're first off, we're gun people that are in the business of supporting gun people. When we started the company, we knew of the numerous other players that had this market pretty captivated at the moment. And after reading their contracts of everybody, we determined that, hey, we can structure an arrangement that gives people and really the citizens of our country somebody that's going to be there when they need us most. That was what we prided ourselves on, and I know that sounds like a marketing piece, but it's the truth. That's why we started the business, right?
You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.